Okay, welcome everybody back to the Vocational Science of Freedom online law class for June 2021. And this is the Redemption of Your Estate class. And this will be part four. And this will probably be our last section for the night. And I'll finish off. Just got done talking about family court and about the Zoom call, the basically pirated Zoom call, because obviously these attorneys did not want this information to be given out about how family court works and how they're getting sued in St. Louis and whatnot. And that was from talking about also connection with the original KW, which was called the Boom Letter. And now we'll get into what happened with Phil's cases. Phil was a gentleman that I worked with for about a year. He's now passed on. We did a lot of work together, and I perfected and finished a lot of the status docs while I was working with him. What Phil was doing, and I'm not suggesting that anybody do this, he was using a Lowe's business account, and Lowe's is one of these big, basically lumber yard places like Menards and Home Depot, that kind of thing. What he was doing was he was purchasing various different things for his business. He was racking up these amounts on the business credit card, and what he was doing was this was some sort of process that Heather Ducci and a couple of the people had like thought that they had figured out, like cracked the code kind of thing, figured out how to get money basically for free out of the treasury. Well, what it was it was just them, and there was a couple other people way back before Heather Ducci ever came along, and they were teaching people how to pay off their mortgages. But again, what it was doing, and their names were Fred and Nina, and I think they were out of Arizona. And anyway, what they figured out was that basically a crack in the system where they thought that you could write a check on what was called the private side of the bank account and be able to clear things. But what all they were doing, and all Phil was doing, because this was like Heather's way of doing the same damn thing, but in a different way, is what they were doing was they were stating in basically like transfers, in like online transfers, that there was some account that they could connect to, and they were using the routing number of a Federal Reserve Bank and using their Social Security number as the account number. And here's the thing, there is no account number like that at the Federal Reserve. When you do this kind of routing transfer, what it does is it clears it instantly, but then within 3 days it'll come back and it'll say that, well, there weren't any funds in the account, and it'll backcharge it. Exact same thing that Fred and Nina were doing, their goofy idea of like being able to pay off a mortgage. There's no money there, but it does confuse the system. Okay. So what Phil was doing what Heather Ducci was saying to do with this money transfer thing. He kept racking up this money and he'd pay it off. And it would look like it was paid off for a week, and then he'd go and he'd charge more at the store, and then it would back bill, and say that their funds weren't there, right? So anyway, he did this over and over and over and over. He racked up like $38,000 on this business card account at Lowe's. Then I got done with the KW and some of the other status stocks. I don't exactly remember how many different status stocks I had done at that time, but I know it was at least the seal notice, the revocation of power of attorney, the executor appointment, the BC claim, and the KW. I know I at least had those five done. Oh, and I probably had the fee schedule done too, but the fee schedule didn't have anything to do with how part of this story with Phil. It only really had to do with the basic the five core documents. And I did not at this time. I know I didn't have done the proof of life and proof of age inquest along with the judicial coroner appointment. So that's the background. Phil's been doing this for a few months, racked up all this money, whatever. So then what he does is, and I didn't tell him to do this, by the way, he racks up the business amount at the Lowe's charge card. And I think the version of the KW that he had done was, I think, 4.0, something like that, somewhere around there. So it had gone through 40 revisions, at least at that point. And it did appoint all the corporations and corporate state employees as trustees of the estate with an executor order to all of them to discharge all debts, accounts, bills, fees, and like against his estate. The executor appointment was finished, I know that. And like I said, with the revocation of POA, the BC claim, and the House seal. Phil had filed all of his status docs that had been finished up to that point, which were these. And this was about 3 or 4 years ago. after he filed what I had done up to that point, he then got a certified copy of all that he'd filed under the public record, and he process served that whole package onto the registered agent of the Lowe's credit division. So after about a week from the date of him serving them, which, by the way, he didn't tell me any of this. He didn't even tell me this, what he was doing. But he just, he was the kind of guy that just did what was logical and just moved forward. So he served them, and in about a week, this thing came back, and this is going to be handout number 17, which I'll pull up. And I'll come back to the Credit River decision and go through that in a minute. But so he serves them, and then this is what comes back in the mail. Account balance summary, zero. zero balance, right? And then it says this from the standpoint of the finance charges, they reversed all of the finance charges, which I've never seen any corporation do before. So they reversed all the finance charges and basically zeroed out the account, which is exactly what what's exactly what Phil told him to do from the standpoint of what the KW said. So that happens. And then about a week passes from this time when all this gets served. What happened was that his son, now he didn't tell his son that he was doing any of this either. So his son goes into Lowe's and to go use the business account to go get supplies or something, whatever they needed for the business. He calls his dad, and I was in the office at the time when he called Phil, and he said, "Hey, Dad, the people at the Lowe's store here," and by the way, they knew his son. The employees at Lowe's were saying that they couldn't find any record that the account ever existed. And they were like, "We don't understand what's going on. I mean, we know you guys. We know you had an account here, but we can't even find that the account ever existed." When his son told him that, he started to giggle, and I asked him, because I was in the same room, I was like, "What did you do?" And he said, "I served them your doc set." I was like, "Really?" And he's like, "Yeah." And I was like, "Okay." I guess that worked. And I never told Phil to use the doc set in that way. He just did it on his own volition. But however, I had told him many times about the child support story, which, I covered up top with the boom letter. So Phil just figured he'd try it out at Lowe's, right? And so that's what happened. The thing came back in the mail, that it was wiped out. The count was zero, and all the finance charges had been reversed. And that was it. That was the end of that account. He never got anything in the mail about, it went to a collection agency. Lowe's never sent him another statement about that you owe anything. The whole thing just disappeared. It went absolutely ghost. And so, this is one of these things, again, that happens when you slap upside the head a corporation. Now, here's a few other things that Phil had done up to this point, which I don't know if made any difference or not one way or the other, as far as the reaction that he got from Lowe's, was that he did have his 32 EIN number back from the IRS. So Phil was one of the ones that got his 32 EIN number. Now, he'd had his 32 EIN number for something like 4 years prior to this, because I learned how to do the EIN number basically from Phil, who learned it from Patrick Devine, who learned it from Gene Keating. And Gene Keating had figured out, because Gene Keating is really, really good about going through IRS things and figuring out all their little back ways of what they do there. And realizing also that it's all about administering the estate. He understood that we're labeled as decedents in the IRS master file and all other stuff that goes along with that. So Phil had his estate EIN number, but I don't think he served his estate EIN number on them, like to Lowe's. I don't think he sent them the letter, at least as I recall. That was the only other thing that he had done. And this thing came back and everything was zeroed out, and it was the end of it. And we never heard anything again at all about it. So that was Phil's little, wipe out the debt thing. Now, to get back to the debt, I kind of skipped over this, but what is debt in this monetary system? Okay, how is it created? What I want everybody to watch, and make sure that if you haven't done so already, is to watch on YouTube the little documentary called Money as Debt. And I put the URL into the outline. I can drop it in the chat too. And so you watch Money as Debt, and it'll explain to you how they're basically creating money out of nothing. There was a very, very, very important court case called the Jerome Daley case from Minnesota, where right after Nixon dropped the gold standard, which was completely unlawful for him to do, but he did it anyway. Once Nixon dropped the gold standard off the Federal Reserve note, Jerome Daley, who was an attorney, by the way, realized that there was no consideration then from any aspect of any mortgage that anyone would enter into. Daly's argument was that, look, I put up my house as collateral. What did the bank put up? And the answer was nothing. Let's open up handouts number 16. This is the Credit River case. So it's First National Bank of Montgomery versus Jerome Daly, defendant. It's findings of fact and conclusions of law and judgment. So this is the judgment from this court. The above titled action came to the court, and this is 41 pages, so I'm going to skip quite a bit of this, but I'm going to hit the high notes here. So the above titled action came before the court on January 2nd, 1969 at 7 p.m. pursuant to motion and notice of motion in order to show cause, a true and correct copy, which is attached to is page 13A. The action for recovery of possession of real property was brought before this court for trial on December 1968, 10 a.m. by jury. A true and correct copy of that judgment and decree is entered by this court on that date, attached thereto. January 6, 1969, this court filed a notice of refusal to allow appeal with the clerk of the district court for the county of Scott and state of Minnesota, which is attached here too. See, what was funny was that the bank tried to appeal the decision, and Daly said, no, they used Federal Reserve notes to pay you for the appeal. That's invalid because this court just determined that Federal Reserve notes are worthless. So the court denied the appeal based on the fact that they paid Federal Reserve notes for the appeal, which I thought was hilarious. So Minnesota statutes annotated require that the appellate, First National Bank of Montgomery, deposit with the clerk of the district court within 10 days $2 lawful money of the United States for payment to the justice of the peace before whom the cause was tried. This was one of the conditions for the allowance of an appeal. And this is kind of underneath the court seal, but it says for the allowance of an appeal. 2 $1 Federal Reserve notes were deposited with the clerk of the district court. One was issued by the Federal Reserve note of San Francisco with serial number whatever, and the other on deposit was issued by the Federal Reserve Bank of Minneapolis bearing serial number whatever. A specimen for illustration purposes is as follows. The court determined that said notes on their face were contrary to Article 1, Section 10 of the Constitution of the United States, and also based upon the evidence deduced at the hearing on December 7th, 1968, the notes were without any lawful consideration and were therefore void. However, this court indicated it would give plaintiff, National Bank of Montgomery, a full and complete hearing with reference to this issue. No hearing was requested, and this court was ordered to show cause before the district court as to why the appeal should not be allowed. Therefore, this court ordered a hearing before the court for the purpose of making findings of fact and conclusions of law. Pursuant thereto, the above entitled action came on for hearing before this court January 22nd, 1969 at 7 p.m. The First National Bank of Montgomery made no appearance, although service of the motion and order was served upon Ralph Hendrickson, its cashier, on January 20th, 1969. No continuance was requested by plaintiff or its attorney. Yeah, after the judgment came down, the Federal Reserve notes are worthless. They didn't want anything to do with this case at all. They were like, oh, God, just forget it. Get out of here. The defendant appeared on behalf of himself. After waiting 1 hour for the bank and its representatives to appear, the court received the testimony of defendant. Now, therefore, based on all of the files, records, proceedings herein and the evidence offered to this court, makes the following finding of fact, conclusion of law, judgment, and determination with reference to the allowance of an appeal. So basically what they said was, you don't get to appeal because your shit is worthless, is basically what they said, which I think is hilarious. So anyway, I'm not going to scrub through all this because, like I said, it's 41 pages. But I think I might have made a few notes in here, or maybe it's in the memorandum. Yeah, well, Article 1, Section 10 of the United States Constitution provides that no state shall make anything but gold and silver a legal tender in payment of debts. The act of the clerk of the district court is the act of the state. The clerk of the district court is the agent of the judicial branch of the government of the state of Minnesota. See, whatever. The Bank of Commonwealth of Kentucky, a state can act only through its agents, and it would be absurd to say that any act was done by a state which was not done by its authorized agents. And also interesting court case to bring up in other situations. The bank attempted to get the clerk of the district court to perform an act contrary to the Constitution of the United States. Exactly. The states have no power to make banknotes a legal tender. See American Amateur Money, Section 13, attached here too. Also, American Amateur Money, Section 9, attached to banknotes are a good tender as money unless specifically objected to, right? Which is exactly what Jerome Daly did. He's like, these things are worthless. Their consent and usage is based upon their convertibility of such notes to coin at the pleasure of the holder upon presentation to the bank for redemption. While the inability of a bank to redeem its notes is openly avowed, they instantly lose their character as money and their circulation as currency ceases. So, Federal Reserve notes are worthless. They're created out of nothing just because there's basically a reason for the bank to create the loan. The law leaves wrongdoers where it lands them. Perfect. And furthermore, at the further memorandum, the jurisdiction of this court is conferred by Article 1, Section 1 of the Minnesota Constitution. The issue power of the state is hereby vested in a Supreme Court, District Court, Probate Court, and other such courts. Minor judicial officials and commissioners with jurisdiction inferior to the District Court, as the legislature may establish. It puts the Declaration of Independence in here, which I thought was interesting. Maybe I made a note. Let's see if I actually highlighted it. Okay, this was the decree about the actual case. What I'm looking for is that there's a specific way that Mahoney writes out in the order. I don't know if I'll be able to find it or not, but basically he's saying, in some place in this order, he says, only God can create something out of nothing. And that's the point, is that the Khazarian mob thinks they're God. Well, their God's Lucifer. But anyway, the point is that they think they can just continue to do this. Oh, and here's a section from, I think this was pulled from Modern Money Mechanics. This is difficult to read, particularly when it's sideways, but that's what Daly did, is he put in sections of Modern Money Mechanics, which basically states that, and some of this is absolutely illegible, and these are all the attachments or exhibits. You can still go to Scott County and you can demand, I mean, you're going to have to pay for the record or, pay for the copies, but you can demand the full copy of this case, the whole thing. And truth be told, I think it would be a really important thing to actually have physically in the VSOF library, that somebody would take the time to sit down and we'll just scan everything in so it looks proper instead of it looking like that garbage, unreadable stuff we were just looking at, whoever, put this PDF together. Because it proves that, yeah, they're creating money out of nothing. So, okay, how are they doing that? Well, it's based on credit. Well, whose credit? Your credit. It's your credit that they're funneling around in this monetary system. So you create the credit from your own signature, which is the property of your estate. Well, just like with Phil, the second that he said, okay, discharge it, Phil created it. He can uncreate it. It's not up to the bank. It's up to the executor of the estate. Or, I mean, more importantly, it's up to the heir of the estate. But in a position of power and use, it comes down to the executor. So that's a Credit River case. Very important case to know, understand, and go through. And there's a couple other handouts. Yeah, just to make a note here. There's a couple other handouts about the Credit River case. There's a Credit River case info one, which is a Word doc, which has 14 pages. It gives a more complete outline of kind of what we were just reading. So anyway, there's that. And then there's also, the other one was Credit River explanation with expanding documents. So this was something that I believe, yeah, Jerome Daly actually wrote this for this little periodical, whatever it was. And he wrote in here basically the reasons what he did to prove the fact that no state shall make or enforce any law which shall abridge the privileges of citizens of the United States. No state shall make or enforce any law which shall abridge the immunities of citizens of the United States. No state shall deprive any person of life, liberty, or property without due process of law. No state shall deny to any person within its jurisdiction the equal protection of laws. Now, all that is the aspect of the 14th Amendment, which I would not argue that. But the point is, you don't have to. The jury said these things are worthless. The judge agreed, and the decision is final because it was a court of record. So yeah, this was written by Jerome Daly. So anyway, this is just more kind of, and some of this stuff is a little bit easier to read. I mean, it's not as jumbled as the other stuff. So you can you can take a look at it and see other information from the case, just in case there was. Oh, and this is all the stuff that's actually printed the right way up instead of being sideways and horrible. So yeah, you can actually read some of the stuff in here from Modern Money Mechanics. So anyway, so that's that. Okay, so that was all of Phil's credit stuff, history, basically. That went down. Then Phil had a traffic case. So he got pulled over for speeding. He told the sheriff's deputy that he was traveling and not driving on the roads and highways. He also told him that he was one of the people of Iowa. The sheriff's deputy gave him a ticket anyway, and Phil said, well, I don't want to sign that. And the sheriff's deputy said, well, if you don't sign it, you go to jail. And Phil said, well, that's a contract under duress, then I'll sign it under duress. And deputy said, I don't care how you sign it, you just got to sign it. Because he's too stupid to know what the word duress means anyway. So Phil signed it under duress. And then what we did was we mailed the ticket back and said, we wrote across it in a 45-degree angle. We said, void for cause, signature fully rescinded. And I think I wrote void ab initio underneath that, maybe, or something like that. And we took a photocopy of that, sent them back the original, and basically, rescinded the signature and said, this was signed under duress. Screw you. And then basically waited for the stupid court case to come in so that we could then put that evidence into the court record. And by the way, I'm pretty sure Phil had somebody process serve, like he actually had someone go down and serve the sheriff serve the ticket back on the sheriff and said, here, this is service. This contract's rescinded because the signature is rescinded. And here's the thing. Everyone has a 72-hour right of rescission on anything. Doesn't matter what it is. I don't care if it's a car loan or a mortgage or in this case a traffic ticket. It's irrelevant. Everybody has a 72-hour right of rescission. Okay, and you don't even need cause. You don't even have to have cause. You just automatically have the right anyway. So we made sure we did that. Rescinded the contract. Okay, so then what we did was I helped Phil. We filed a counterclaim in court of record for trespass and trespass in the case, and it included a print off of the court's Dun and Bradstreet number, proving that the inferior courts were nothing but for-profit corporations. And this is Phil's counterclaim, is law of the case, and then the Dun and Bradstreet number. Now, the counterclaim is going to read much like Drew's counterclaim. I mean, it's going to have the same, layout and feel to it because it's just how you're supposed to do it. But obviously, Phil had his own law, which I'll bring up. I'm going to focus on the law more. But so anyway, so you do the facts, statement of cause, what it was, what happened, blah, blah, blah. Everything that went down. And conclusion regarding the first count of trespass, that they didn't have the right to do what they did, and that the cop forced him under duress to sign a ticket. And then count 2, trespass on the case, state the facts again for what that is, And then count 3, action non-assumpsit. And non-assumpsit means I don't owe anything, basically. That's what that means. So he's saying I don't owe anything because there was never a valid contract. And then the pledge, conclusion, demand what he wanted, and notice of default. Again, state and relief required by nil dissent default judgment against the counter defendants if they don't say anything in 30 days. And then verification and signed, sealed, and delivered. Same thing as the other one. So nice, simple, same deal. Now, what I will get into, open up, is I'll show you guys law of the case. So law of the case starts with, and I'm not going to go through the whole thing because it's already 6:15 and this is 35 pages. But point to give it to you is that so you guys can use this. You can use this as a template for your law of the case for pretty much damn near anything that the state tries to do against you. It's a pretty good solid law of the case for all of that, but specifically traffic, because down in the bottom here, after you get through, sovereignty and rights of the people, the word people, and the people are sovereign, all that good stuff. Reservation of sovereignty, meaning that we don't waive our sovereignty because of a contract. I put the Expatriation Act in here to basically tell them, look, this guy has expatriated already from the status docs, what a Republican government is, what a citizen of the United States is, what money is, what contract is, what consideration is, claims, public officers, right to travel, and then right to travel you could get rid of if it obviously wasn't a traffic ticket. So that's why there's quite a bit of a right to travel stuff in here. Which goes on for several pages, because obviously that's what the case was about. Jurisdiction, when the court has it, when it doesn't. They can't just say they have jurisdiction because they say so. So jurisdiction goes on for what? Treason, I threw that in there just to scare them a little bit. Due process, what that is and what it's not. Particularly, and by the way, when I was talking yesterday about, this is, for anybody, sorry, if anybody's listening to this class that doesn't attend the regular Wednesday night brainstorming sessions or Saturday night free classes, the other day I was talking about the requirement of the arresting officer to take the accused directly before the nearest magistrate where the arrest was made without order. It doesn't matter if it's on order or not. It doesn't even matter if it's on a warrant. I mean, they still have to take you directly before, immediately, a magistrate, the nearest magistrate where the arrest took place. And by the way, this was Heath Boyd. This is out of that case that I was talking about. So moreover, if Heath's arrest had been authorized by the statutes, his subsequent detention, as pleaded, proved would make a case for false imprisonment against Boyd. Boyd was the sheriff's deputy. The undisputed facts are that after his arrest, Heath rode with the sheriff to the former's car, which he then entered and drove several miles to the courthouse, followed by Boyd. There he was detained in Boyd's office from 1 to 3 hours while Boyd was seeking advice by telephone as to what to do. In the face of a plain statutory command as to what must be done in all cases of arrest without warrant, Article 217 CCP 1925 provides, quote, in each case enumerated in this chapter, the person making the arrest shall immediately take the person arrested before the nearest magistrate where the arrest was made without an order, close quote. Substantially the same requirement appears in these other articles. Presumably, there was a magistrate in Mertzon, the county seat, yet Boyd offers no reason why he did not take Heath before that official. Neither in his pleadings nor in his testimony does he suggest that a magistrate was not reasonably available, although the arrest and detention all occurred between 8 o'clock in the morning and noon. If he had taken Heath to that official, he could have gotten the information and assistance he was seeking by telephone. He was under a positive duty immediately to seek a magistrate. That such failure, unexcused, takes a case of false imprisonment as a matter of law is held by all the authorities. You can file a Title 42, deprivation of rights under color of law, in federal court every single time they take you directly to jail. I don't give a shit what the reason is for it. Zero. It doesn't matter. The second they break this, you've got their ass. And because the cop is always going to be the one that testifies as to, what you did or what you didn't do or what he arrested you for, all of his testimony is defeated. All of it. Because you can't trust a criminal to give proper testimony. Period. So, with that, you can use this case and the other one was Heath Boyd and Gerstein Pugh. Let me see where that is. Wait, Gerstein Pugh might have been above it. Yeah, it was. Okay, this is Gerstein Pugh. This is Florida Federal. When the stakes are this high, the detached judgment of a neutral magistrate is essential if the Fourth Amendment is to furnish meaningful protection from unfounded interference with liberty. Accordingly, we hold that the Fourth Amendment requires a judicial determination of probable cause as a prerequisite to extend restraint of liberty following arrest. If you don't take them before a magistrate, they're screwed. And you can take their house. And if you got your doc set done, well, you can take their house without even having to do a Title 42. But if you start looking up the percentages of Title 42 cases, which are, that's a federal case, which is deprivation of rights under color of law, you will find that like 80% of them get settled out of court because they know that that's their ass. Instead, they'll settle out of court so that they don't have to have a judgment against them to say that, yes, they did that. That's usually what happens. So, I know at least one person on this call who can totally do that right now with the gentleman that he was speaking to me about. So there's your Gerstein Pugh and your Heath Boyd. And so I'll just scroll through the rest of this now. So it's got stuff about venue, where you should be, warrants, what a warrant is and what it's not, and when you can do one or not do one. This one from Justice Marshall I love using this one. This is like, I use this in every single habeas corpus, because when I do a habeas corpus for someone, I do a constitutionally based habeas corpus, and what I demand is that they produce the damaged party, not that they produce the body of the defendant before the court, but I demand that they produce the damaged party before the superior court. Because if there's been no harm, they never had jurisdiction to hold you anyway. So anyway, what Marshall says is, the question is, what authority has the jailer to detain him? To ascertain this, we must look at the warrant of commitment only. Let me read that again. To ascertain this, we must look at the warrant of commitment only. If there is no warrant of commitment on the record of the court, it's automatically unlawful detention. It's automatically false imprisonment. I don't care what the fucking statutes say. If there's no common law warrant of commitment, it is false imprisonment. Plus, on top of it, when you really get down to brass balls about it, it's the second that any cop is displaying a deadly weapon on them and they take you someplace where they're not supposed to, that is aggravated kidnapping. It is that only which can justify his detention, meaning the warrant of commitment. That warrant states no offense. It does not allege that he was convicted of any crime. It states merely that he had been brought before a meeting of many justices who had required him to find sureties for his good behavior, right? Which is all that statutes are. Don't do that. Don't be a bad boy. Don't smoke marijuana. You've been a bad boy. You have to give us money. No, screw you. Wrong. It does not charge of their own knowledge or suspicion or upon the oath of any person whomsoever. The judges of this court unanimously of opinion that the warrant of commitment was illegal for want of stating some good cause certain, supported by oath. So, if you don't have a preliminary hearing, which states some good cause certain, supported by oath, meaning good cause, meaning there's a damaged party, you don't have a valid warrant of commitment. If you don't have a valid warrant of commitment, guess what? You can file a habeas corpus and say, where's the valid warrant of commitment? Because I need to ascertain find the damaged party. Where is it? They can't produce it. They can't hold you. Plain and simple. Unless, of course, you're being held by a grand jury, but we won't get into that. All right, so I'm just going to skip the rest of this. But all the rest of these fun things are, the Bills of Rights sections, state Bills of Rights you can put in. I have some articles from Magna Carta, which kind of connect with the KW. And then I got a whole list of maxims, which are fun. And then the seal. This is a specific part of your law of the case, which you want to make sure that you come to the law of the case and put your little gold seal here, because this establishes that your house seal is the seal of this court, and it's decreed so by the sovereign of the court by law. Okay, and then I've got a little writ procedure here in case anybody, because they've tried to abolish all writs, so I just created my own little process for doing writs and execution thereof, whatever, and it's taken from a treatise on writs, so it's all valid. And then verification. So plaintiff has decreed the foregoing law of the case, and all actions are in, and is filed the same with the clerk of the court. Plaintiff declares under penalty of perjury, under the laws of the United States of America, which means without the United States, by the way, that the foregoing is the decreed law of this case, and that the foregoing was filed with the actions in this case and was executed on the land in the county of Lee, Republic of Iowa, blah, 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 blah. Philip Francis Telephonic, blah, 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 and then your test date and boilerplate seal. Have a nice day. Okay, so that's the law of the case for you. So Phil filed his counterclaim, the law of the case, and then and this was the funny thing, he process served the judge in chambers with the status docs that we had gotten finished up to that point. So the judge was aware that if he went forward with the trial in the inferior court side, he would become a trustee of Phil's estate. That judge recused themselves from the case. Then another judge came on, and we served them the status docs, and they also recused themselves. Then 3 days before the trial was supposed to happen, they appointed some magistrate out of another county to come over to hold the trial. We didn't have time to serve his ass. It was too short of a time period. But instead what Phil did, is he said in open court, he said, I filed such and such documents, and I've served so and such documents on such and such judges. They should have made you aware of these documents. Do you understand what I'm talking about? And the magistrate was like, no, I don't know. Okay, look for such and such document in the court record. It should be in there. And he sits there and shuffles for like 5 minutes, like pretending not to. I don't know if I can see. Well, I've got a copy right here for you. I said, Phil says, may I approach? Which is the polite way of saying, I'm going to walk up here and give you some. And so he comes up, gives it to him. He's like, okay, you're now on notice of the fact of what I just handed you. He's like, well, what is this? He's like, well, you can read it later in chambers if you want. Or I'd be happy to take a recess and you can read it now. Which the magistrate didn't do. He's just like, well, okay, well, whatever it is, we can get to that later. Not realizing that what he just did was just agreed to the contract, which was funny. And so anyway, so Phil basically has then appointed him as the trustee. So the case went to trial. Phil made sure to verbally appoint the magistrate as trustee the next time he came into court of his estate, and made him aware again of the status docs, which the magistrate was none too happy about, because at this point he had now read them. Knowing now why they had asked him to come all the way from another county, and why 2 other judges had previously recused themselves. This guy realized he just got caught. And he realized he got thrown under the bus by his colleagues, which I'm sure didn't make him very happy. So also in the trial, and this is another interesting thing that happened during this, but it's another one of these holy shit moments where you're like, really? That really happened? So what Phil did is he had a friend who formerly worked for the State Patrol, who was also a student of mine at the time. He asked his friend to take the stand. He said, so can you point to the defendant today in the courtroom? And the man said, yes, it's right over there on the table. And he pointed to the table, and Phil walked over and he picked up the authenticated BC. And he said, is this what you were pointing at? And the guy said, yeah, that's the defendant right there. And there was no objection from the district attorney. The judge didn't say shit. Literally the whole courtroom just fell into silence. Like, wow, did that just happen? And we have the transcripts for that, by the way. It's just hilarious that the fact that happened. But no objection, nothing. So I think, and I'm not sure, but as far as I know anyway, my students are the only people that have ever established the fact that the BC is the defendant in open court without objection. Now, granted, it was only for a dinky traffic ticket, but it doesn't matter. A fact established is a fact established. I was never argued. Like I said, district attorney didn't say anything. I wasn't physically there, so I only heard the story when everybody came back from court that day, because I was busy. I had to write up a few other things, so I couldn't go with them. Somebody else. But they all said, yeah, the judge looked like slightly stunned and pissed off at the same time, kind of caught like a deer in the headlights. So later, even after all that took place, the jury found in favor of the state, because obviously they're idiot sheep and they don't know any better. So in the last hearing, which was held in a small room, and it was not a courtroom, and this was basically the sentencing hearing, the magistrate was acting really, really weird. Like he was like fiddling with the computer and like looking at other things, and like I think what he was trying to figure out was, how the hell do I get out of this? Yeah, because this guy could take me into binding arbitration right now. So anyway, the last hearing. So by this time, the magistrate was well aware of his accepted position as trustee, which Phil said to him. He said, "Are you aware that you've accepted the appointment as trustee of the res defendant estate?" To which the magistrate bowed his head down, almost like under his breath. And this is what everybody else said that he did. He just kind of like bowed down and said, yes. So then what the magistrate did was he said, well, the jury found you guilty, and I'm going to set the fine for $20. And everybody was like, what? And it was like a, I don't know, $189 traffic ticket or something like that. But everybody was like, they were like, what? $20? What? We've never even seen or heard of anything like that before. Now, why did the magistrate have to do that? Well, he was kind of in a funny way getting him, or best as he could, getting himself out of his own predicament. Now, the reason he had to make it so low is because if he went over $20, the entire matter would then have had to have been considered under the common law, where Phil would have then, had the bailiff been able to arrest him the judge, for common law theft because he was administering his estate without Phil's signed and sealed consent. But if the judge kept it under $20, you see, the federal constitution states that any matters over $20 are considered to be in the common law, over $20, which is why I tell everybody to put $21 in stamps on your signature line when you do your KW, which some people adhere to and some people don't. But you can get a fun little felt tip, either gold or purple type marker, and then sign your name over the $20 in stamps. And you can get like an over $21 stamp, just a single stamp at the post office now anyway. And that's why I tell people to do that with the KW, so that the KW itself, then the document itself, is put into common law. So anyway, the magistrate he knew where he was, and from the standpoint that he could be arrested right then and there, was exactly where the magistrate did not want to be. Well, yeah, things get into RICO from you could have done something in RICO from the standpoint that you could have attacked the whole entire court system. See, when you want to do RICO, it's like you want to take out the whole entire system altogether at once, basically. So Phil was just filing suit against the sheriff's deputy and the inferior court for not having jurisdiction, basically. That's all Phil's fun stuff that that he did and we did together. Okay, so now on to Brian McFadden's case. Now this is a debt case that this guy had gotten behind on payments to a guitar vendor to the tune of $8,500 or thereabout. And after seeing what Phil had done with his suit and the debt discharge, he process served the KW onto the corporation that was suing him for that amount. Okay, so this is, and number 19 was what happened after there was one other thing I was going to show you with Phil's case. Sorry. I was going to show you the screenshot from Dun & Bradstreet. Obviously, Phil, this was the one that, he looked it up for his own case. The following is the DUNS number for Judiciary Courts of the State of Iowa. DUNS number. What's weird about Iowa is that they have one DUNS number for all of them. It's the same number. Somebody else in Iowa, what they did was they tracked down the money, and they found that the money went to an American bank here, and then it went to a bank in Israel. And we were like, oh, okay, that figures. But anyway, and unfortunately the man that tracked all that down is now also passed on. He was very, very good at research, but he was horrible at organization. I may or may not have the information because I made sure that I copied all of his hard drives, at least a year or two back. I almost need an army to help me go through them because there's file inside a 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 file, because it was all based on a Mac operating system, where a Windows operating system only lets you go so deep in files. Macs will let you go like forever deep in the filing system, and so you can get stuff that just gets lost in there. And anyway, but point is, I know he was right because it makes perfect sense, and he told me about how he had tracked that down. I don't know if I'll be able to pull that up again, but anyway, like how, okay, so let's say the difference is that in Illinois, what they do is, like, each county has its own Dun & Bradstreet number, and then each district court has its own Dun & Bradstreet number, and each judge has their own Dun & Bradstreet number, and each district attorney has their own Dun & Bradstreet number. That's how Illinois does it. So I don't know if it's just, you can just count it up to Illinois is that many times more corrupt than Iowa. I don't know. So you can go on to Dun & Bradstreet and look this up for your own court. And all you got to do is set up an account with Dun & Bradstreet. You can just say, yeah, I'm a business, and here, I want to have my own Dun & Bradstreet number. And then you can look up anybody else's Dun & Bradstreet number after you do that. So that's the fun thing you can do. Back to Brian's case here. So he filed the status docs into the case, which Phil didn't do. He just served them onto the judges. I don't think Phil ever actually filed it into the court case, but I don't recall, he might have. But anyway, so this court case, this is what they sent back after like a week after they got process served, that the registered agent got process served. Basically everything that Phil had done. The seal notice, the revocation of power of attorney, the executor appointment, the kill warrant, and BC claim. So he served that on the registered agent of this corporation out in, I believe it was California. Within a week, this is what the attorneys did. The attorneys wrote this up and put it in. So it was dismissed. It does say without prejudice, but they have never come back to refile anything. So with prejudice means that we cannot file the reclaim. With prejudice means we can refile the claim if they want to, but they've never come back to ever try to get it. And so again, this was sent to him after he'd served it. So you guys are, and people and men have done this, by the way. You're happy to go look this case up and pull it. You'll see the KW in there. Now, I'm kind of telling everybody in here, but I think all of you, pretty much all of your doc sets anyway, or else you're lifetime members and you got the information already, so it doesn't really matter. But there have been men that have gone and pulled this entire case, and they were like, yeah, as soon as it got filed, this thing got put in by the attorneys to just get rid of it. They were like, no, we're not dealing with the $150 million in liability. Screw that. You know, not over $1,800 of, or $8,500 of, you know, debt payment. They just disappeared. So it was just one more thing that just went bye-bye the second that they caught wind of it. There's a couple more things that I want to reiterate here about what we can do when we all start getting this stuff done. What I've shown you guys is the unequivocal facts of how the status docs have done these various different things and the reasons why they worked. Now, I'm not always 100% sure of some of the reasons, but the basis of of how the court system works and my understanding of it is solid. Of that, I have no question about. In seeing what Stark did, right? I mean, there's no question the power of that either. So you put all this together, you can say 100% that we're right. Okay, so now that we know we're right, what should we do with it? One of the things we could do is form de jure grand juries of 25 members of the peerage, which of course, and I gave you guys the playlist off of YouTube for the grand jury classes, most of which everybody in here has come to on various different Saturdays. So the point about once we get the status docs done is that we can start forming grand juries, and all the information of what we can do and the power of it and so on and so forth is in the list, for the watch list. The other thing is that I can't see any reason why we can't confirm our own arbitration awards in our own courts of record. It makes perfect sense to me. The confirmation of an arbitration award regarding the administration of your state also would be, as far as I'm concerned, considered to be a matter of life and limb. So again, it must be considered gratis. Now here's the thing. It's not like all the state statutes that are out there regarding confirmation of arbitration awards do not all clearly state that they must confirm the award. It says exactly the same thing in Title IX. The UAA and the FAA are completely in agreement with the fact that, yes, if you have a binding arbitration award and it has not been challenged or altered or anything within 90 days, it must be confirmed. So if these corrupt bastards are getting to the point where we're not going to confirm it, fine, screw you, we'll do it ourselves. And then we'll just show up at the door of whatever judge with, 20 armed militiamen with the court order of the fact that it's been confirmed, along with the arbitration award, along with the notice of understanding and intent that he'd been served or she'd been served, telling them that we were going to come on such and such a date, and informing the sheriff that you're doing it too. Because if they don't want to help, fine, but they better stay the hell out of our way. Because I'm not playing around anymore. When I see things like Stark, getting paid billions of dollars from the United States Federal Corporation, basically because he was, probably because of the payoffs. $2 million to each senator and $2 million to each representative. That's pretty easy to get paid off from. Am I saying what Stark did was illegitimate? No, I'm just saying what Stark did was damn sneaky, but it worked. And what I'm saying is that what we're doing, there's nothing sneaky about what we're doing. What we're doing is we're putting everything front and center, being like, look, there's nothing we're doing here that's incorrect, unlawful, or invalid. So with that, I will continue to talk about arbitration awards, in the coming days as, just as to keep everybody apprised of what's going on. I think we should start working on the committees for the National Popular Assembly. And those of you who are Vocational Science and Freedom members. I'd like to start up the Council of the Wise again, because there's a lot of things that I could use help with at the moment. Putting together ideas for advertisements and promotion and all that good stuff. That's all I've got for the evening. That's the end of the timeline, or the end of the document, the outline, I guess the best way to say it. And so if any of you guys have any questions, I'll be happy to stay on for a bit longer if you guys want to ask me anything.
I got one for you.
Sure.
So, Jen, if we go into an action of law, we actually ended up in front of the courtroom. Counsel, do we make him a special master, or can someone just be there as counsel?
If you're going to have somebody else in the court with you that's going to kind of help you out, I would make sure to do a special master appointment, because then once you do a special master appointment in your Superior Court of Record, you tell the judge, be like, Your Honor, this is my appointed special master. This is why he's in the courtroom today. There really isn't anything they can do about it, because he's an officer of the court, because the special master becomes an officer of the court.
Okay, you don't need to file that in the suit, or you don't need to file that?
Yes, you do. Yes, you do. Yes, you do have to file a special master appointment into your suit, and make sure that you file it into your case number. And then make sure that you send a copy of it to the opposing party, just like you would with a motion or anything else.
Okay, and this is a little off topic, but not really. You're talking about status documents. I've got that one that you sent the appointment to the Office of the General Executive for the wife, right?
Yeah.
I'm sitting here reading it, and it doesn't quite make some sense.
Tammy wrote that one, and there might be some lines in there that, I mean, go ahead and ask your question, because I had to ask her, like, what the hell do you mean by this? So hopefully I can answer it.
Okay, at least I'm not alone. Well, it let it now be known and evident and all that, and it's being signed by the husband, right? The spouse.
In the signature line that's like in the middle of the document is signed by the wife. The husband signs the bottom of it.
Okay, that's right. Okay, but so this document is being declared by the husband, by the man, and yet it says that I, the living soul manifest, known as woman, donor, dignitary of status, known as, whatever, which is the birth certificate name of the wife, right? Go back and read it.
No, it shouldn't be. I can just, wait, hold on. That I, as a woman, soul manifest as woman, donor, state heiress, dignity, with knowledge, accepts all that is the complete will and testament of the state name known as Mary Jane Roe, as special deposit. That's where she signs. Born, created, delivered on birth date through the hand of mother. Okay. Now appear before and lawfully and irrevocably appoint John Henry House of Doe to the office of absolute general executor, to action the need of arise to the commercial realm for all interests to absolute authority regarding the estate name known as Mary Jane Roe, also known as Mary Jane Roe.
I think you get the point. I think that you need both signatures down at the bottom. I mean, because she's signing. I mean, she's the one that's pretty much writing the document, and yet the man, the spouse, the man in the house, should be accepting her appointment, right?
Well, that's not exactly the way you want to think about it. The way you want to think about it is that the man basically claims her away from the corporate state, is a better way to think of it. So she says, okay, and then it continues, I willfully enter the house of Doe, forsaking all the houses, and allow the paterfamilias of said house to heaven to hold me for as long as we both shall live. This appointment is by in accordance with the Powers of Appointment Act, common law, bloods and right, kinship, blah, blah, blah. Regarding appointment by will, law, contract, free people. Okay, so let it be known to all concerned persons, member-wide, notices, free member writing, exclusively for the house of Doe, emanating seal of general executor and the paterfamilias of the house is created by his hand, will be considered as the only valid authorization of any commercial legal actions regarding said estate. I mean, no, it's not. I mean, it's not wrong. I mean, I know it's not wrong from the standpoint that it on the top, it's talking about what she is, what she's agreeing to be a special deposit, and then last sentence, I willfully enter the house of Doe, forsaking all the houses, and let it be known by all concerned persons that the embossed seal created by will be considered the only valid authorization of commercial action regarding said estate. No, she's still saying that, but he's the one that's signing and sealing it, because once See, once she comes in as a special deposit under the house, guess what? By the end of this document, the male is her executor. So he's the one that has to sign and seal it under his seal. So there's nothing wrong with that doc that I can see.
No, okay, it's a little confusing, but the way you explain it now, it should be. You might want to put a line in there saying it is hereby confirmed. Then husband's signature.
I don't know.
Say accepted.
I wouldn't. Well, I wouldn't want to say confirmed. Accepted would be okay. Acknowledged would probably be a proper term. I'd probably want to put it like an acknowledgement.
Yeah, that's what I'm thinking because it's slightly confusing, and she's already signed it in the middle. I get
Yeah,
that.
yeah,
That's great, and then he's acknowledging her, and that's basically saying until death do us part.
yeah, yeah. Because she acknowledges the aspect of what her own will is up here as a special deposit. But yeah, I don't think I have the word acknowledged as far as the what basically when the man is saying it. So yeah, I suppose I could put that in there. It's not going to hurt anything.
Okay, I'm not so confused now.
Okay, cool. Anybody else anything? Anything I want to talk about or have questions about?
Mr. Question Man here. Uh, Got a guy that's was born. He was in the military, born in Uruguay, and
Oh yeah, you told me about him.
yeah, and he got his authenticated, and he thinks it's a document from Uruguay. Um, Actually has his lineage on it, which is pretty interesting. I haven't seen the document, but he wouldn't have to go to the U.S. Secretary of State to get it, would he?
No, you'd have to get it authenticated from the country of its origin. That's where you have to get things authenticated from. Which there's probably a process for, but I have no idea what that would be.
Although he was born as a military dependent and brought into the country as a citizen of the United States.
Yeah, that's true. Yeah,
Think about it.
yeah, I'd have to think about
Hey, we got a lot more other things to go in. I just kind of blew him off because he's not a very honorable guy.
it. Well, yeah, there's your first problem. So, yeah, I don't deal with anybody anymore. It's funny you bring that up. The beginning of this year was a really weird time for me. Like it's almost like the universe forced everybody that was shady or nice not nice people to me or uh, even people that I found out had stolen from me. The universe basically removed all of those people from my existence. Like just got rid of them, and I don't mean killed them, but basically made everybody else that's around me see them for who they are and basically ostracize them. And I don't deal with them. They don't show up. They don't call me. They don't email me. They all just poof, vanished. So, but it was my mentality that I'd been having for a long time. I kept saying to myself from a standpoint of kind of like a mantra saying, I'm so happy and grateful now that I'm surrounded by intelligent, passionate people. Um, that of course excludes, idiots and thieves. So yeah, I made a determination after that happened. I'm like, okay, that happened. That's good. And you know what? I'm never ever going to bother to, you know, mess with anybody that's anything of that, negative ilk. Yeah, Poseidon, the YouTube link will be available for the class. I'll put together the same little thing that I do and have done in the VSOF member room, the lifetime member room. So I'll drop them in the links down in the VSOF lifetime member room, and I'll drop them to everybody who paid for the class who's not a lifetime member, like you and John and a few other people that actually didn't show up to class, but they obviously want the class, so they're cool with just getting it afterwards. So yeah, I'll get to the same way that I did before with, and you can of course take the link to the classes. But here's the thing, honestly, Poseidon, everybody, you already have them. They're already in this room because every single every single I'm getting tired. Every single link for each section of the class is already posted in this classroom and I made sure to label them part 1, part 2, part 3, and part 4. So the second that I turn off this broadcast and I stop streaming, it will automatically save as number 4, and you can go back and watch it as long as you're clicking on this URL that I have. So technically, you have them right now. So, but I will put them together and make sure that they're all correct and put together the link with the thing, and make it like I do with all the rest of them. I thank all of you tremendously for coming and supporting my work. I look forward to getting together the task committees and putting out feelers for anybody else that wants to help for all kinds of fun stuff like recruiting and research. With that, like I said, I thank everybody for coming. It's fun to tell all those stories, and so that people know, this works, and that things that are even greater and bigger also work, and like Stark stuff, and that this is doable. So thanks everybody, and I'll see you all when we do the roundtable. So with that, have a wonderful night, and thanks for your support.